Hi, Jan Boback from Anderson & Boback, talking about collaborative divorce process today. The collaborative divorce process is where parties to a divorce decide to do things in a collaborative or non-litigious fashion as opposed to going to court. Now, if you and your spouse decide to participate in a collaborative process, of course it requires an agreement that you're both going to participate in this collaborative process, and you each retain your attorney. You'll sign an agreement with your collaborative attorney, your respective attorneys, and then you will each jointly, pursuant to that agreement, retain the professionals. And the purpose of retaining the professionals is to help you jointly work through some of the issues. Now, the professionals that are involved in this process are not only your own respective attorneys, but you also have potentially appraisers and accountants, business evaluators, realtors, mediators, counselors, coaches, a therapist, anything to do with your specific situation. If there's an expert required, you would hire that expert as a team, and that would be a neutral party that's going to help you resolve these things. Now, the benefit of choosing to retain these professionals jointly is that in a litigation sense, you would each hire your own independent tax expert or business evaluator or realtor. So although you're hiring these professionals and you're outlaying some money initially, it's potentially cost savings because you only have one and you're doing it as a joint effort. One thing that's important to remember is when you're in a collaborative situation, there's no discovery. And discovery is really one of the most expensive pieces of a litigation case. When you're doing discovery, you send out requests to produce documents, you send out interrogatories for questions that need answered, and then you have to gather all these documents, bank statements, retirement statements, your checking accounts, your checkbooks, your savings, your brokerage accounts. All these documents have to be gathered, generally for a period of 3 or 4 years, and exchanged with the other side. So it's very document intensive and it's very time consuming and expensive to go through all these documents. In the collaborative process, there is no discovery, but it's voluntary for every party to disclose all this information. So all these statements that we talked about, all these documents, they're voluntarily exchanged, they're voluntarily put in notebooks for everybody to have access to, including your experts, so that the solutions can be reached during a collaborative or mediated process based on everybody having the information. The other thing that you don't see in a collaborative divorce situation is depositions. In litigation, a lot of times the parties will have to sit for a deposition so that your attorneys can ask the other party questions, and they kind of use a deposition to gauge the other party. What will they say? How do they act? Is there some questions that puts them under pressure? It's really just a trial run to know what are they going to say, try to pigeonhole them into what they're going to say, because you will use that during litigation. And in the collaborative divorce process, again, there is no depositions. There's oftentimes when you're meeting in the same room, there's oftentimes your attorney's going to be asking questions to the other side, but it's not in an adversarial litigation process like a deposition. It's simply to move through the process in a collaborative way. Now, once you reach an agreement in this collaborative divorce, you sign the papers, you have the same marital settlement agreement, the same judgment, the same paperwork that you need for a divorce, but you do it in your offices, everybody's in agreement, it's signed, and then you go to court, you ask the court to approve it. And when you reach them by agreement, you own your agreement. You don't have somebody in a black robe telling you what's best for your children, or telling you what to sell, or telling you who's going to own what. You're making those decisions on your own. So whether the collaborative process is right for you or not, it depends on some of the options that we've talked about. It depends on you and your spouse's ability to put aside your litigation caps and decide to work through this collaboratively. Jan Boback from Anderson & Boback, please give us a call if we can help you with any of these issues.